The dangers of using an asset dump and buyback strategy to escape liability for SBA loan debt. There are some non-attorney loan workout companies out there that are actively promoting an asset protection plan for small businesses with troubled SBA loans, wherein the small business transfers its assets in a self-interested transaction, also known as an asset dump and buyback strategy. We receive calls from troubled small business owners with an SBA-backed loan who have heard about a foolproof strategy that is supposedly guaranteed to strip their business assets of an SBA loan debt so that they can continue to operate the small business, while getting the SBA lender or the SBA to go away and leave them alone. In general, an asset dump and buyback strategy can follow these parameters. Your small business is in trouble. However, you have a friend, family member, or some connected third-party individual who sets up a new company to buy your small business's assets at liquidation value, where you secretly provide the new company with the money to purchase the targeted assets in a private, controlled sale. The SBA lender or Certified Development Corporation, CDC, with the approval of the SBA, agrees to the private sale, believing that the sale is a fair arm's-length transaction. After closing the private sale of the assets, you then submit an offer in compromise to settle the remainder of the SBA debt or try to file for personal bankruptcy. Thereafter, you either buy back the business assets or the new business from your friend, family member, or connected third-party individual, or otherwise you may be employed as a manager of the new business but are able to enjoy all the benefits of ownership of the new company. There are several issues that arise from trying to perpetrate such a scheme, as it is possible that some SBA lenders would view such a transaction as fraudulent or involves collusion, especially if the small business owner fails to inform the SBA lenders of the true nature of the relationship. Moreover, it should be noted that on the SBA offer in compromise form, it states that one of the key elements for a workable offer is that there is no fraud or misrepresentation. Thus, it can be argued that a material omission may conceivably be construed as fraud or misrepresentation, such that 18 U.S.C. 1001 has been implicated and potentially violated. Small business owners saddled with SBA debt, who are considering using an asset dump and buyback strategy, should seriously review this federal statute and the potential consequences by clicking this link. 18 U.S.C. 1001. All SBA-backed loans require the SBA lender or Certified Development Corporation, CDC, obtain a lien against all of the business assets of your small business through a UCC filing. When a UCC filing has been obtained, this means that you are prohibited from selling or transferring your pledged business assets without the permission of the SBA lender or CDC and without the proceeds going to the SBA lender or CDC if you still owe on the SBA loan. Case in point, in a recent federal bankruptcy case, United States v. Bushy, the defendant tried to preserve his small business by utilizing the asset dump and buyback scheme as outlined above. Once the United States trustee discovered that Bushy had provided the money for the purchase of his business assets and acted as a manager of the new business, even going so far as to buy himself a new Porsche, the United States trustee filed suit. Bushy lied under oath, denying that he provided the money for the new business that purchased the assets. The court sided with the trustee and denied Bushy a discharge in his case with respect to any and all of his debts. This means Bushy remained personally liable not only for SBA-backed loan but all other debts he may have sought to have discharged through his bankruptcy filing. Bankruptcy was no longer an option for him, and Bushy put himself in a position to be charged with perjury by the United States government for his actions. Some of the key facts and findings from the case have been reproduced below. The sale of Sun Center America, Inc. to Alameda Assets Management, Inc. U.S. Bank acquired First Community Bank and became the holder of the loan. Mr. Bushy contacted Second Wind Consultants, Incorporated, Second Wind, sometime in 2012 to assist him with respect to the loan. He executed a contract for services from Second Wind on November 15, 2012. Second Wind's stated strategy was to prepare for the implementation of the workout, which will include A plan to protect the business assets from the secured creditors, and B, if appropriate, design and implement the asset sale, which is the foundation of the reorganization. The contract for services also contemplated that Second Wind would assist in settling Mr. Bushy's personal guarantee of the loan once the assets are transferred, and thus the business is reorganized under a new entity, with the assets, the collateral for the original loan, being released by the bank. On September 20, 2013, Sun Center and Alameda Assets Management, LLC, Alameda Assets, entered into a purchase and sale agreement for the sale of substantially all of Sun Center's assets to Alameda Assets for $30,000. Mr. Duggar owned 100% of Alameda Assets. The amount of the purchase price was the amount U.S. Bank agreed to accept from the buyer in exchange for releasing its lien against the assets. Mr. Duggar did not have any direct contact with U.S. Bank before the sale. Nor did Mr. Duggar have any direct contact with Second Wind regarding the transaction. Mr. Duggar understood that Second Wind prepared the documents for the transaction. Mr. Duggar agreed to the asset sale to help his friend, Mr. Bushy. Mr. Duggar does not remember reviewing any profit and loss statements, tax returns, or payroll records before agreeing to purchase the business. Even though Mr. Duggar was willing to help Mr. Bushy, Mr. Duggar made it clear that he would not put up the money to purchase the business. Mr. Bushy would have to come up with the money himself. U.S. Bank released its lien on the collateral pledged to secure the loan to Sun Center upon its receipt of $30,000. U.S. Bank agreed to accept $30,000 in exchange for releasing its lien against the assets based on its belief that the purchase and sale transaction was at arm's length. Mr. Bushy, on behalf of Sun Center, and Mr. Duggar, on behalf of Alameda Assets, signed an affidavit of arm's length transaction in connection with the sale of Sun Center's assets to Alameda Assets. A notice of value issued by the Bernalillo County Assessor in May of 2013 valued Sun Center's business equipment at $90,356 for its business located on Montgomery Boulevard. Mr. Bushy took an active role in perpetrating a scheme to form a new entity to acquire Sun Center's assets and obtain a release of lien from U.S. Bank by falsely making it appear to be an arm's-length transaction. Mr. Bushy's secret funding of the purchase price, and emails from Mr. Bushy to Second Wind, support this finding. Mr. Bushy's email communication to Second Wind also appears to confirm that Mr. Bushy put up the $30,000 purchase price. In his email, Mr. Bushy wrote, "I have basically lost an additional $30,000 in cash this year due to the circumstances of the workout not going according to plan." Mr. Bushy never informed plaintiffs of Sun Center's asset sale to Alameda Assets. A bankruptcy discharge is a privilege, not a right. Juzwiak, 89F.3d at 427. See also, Villante v. Gordon, in re Gordon, 509 BR 359, 370, Bank ND Oklahoma 2014, a discharge in bankruptcy is a privilege, not a right, and should only inure to the benefit of the honest debtor. Quoting Juzwiak, 89F.3d at 427. Debtors who play fast and loose with their assets or with the reality of their affairs may find themselves ineligible to receive a discharge. Butler, 377 BR at 927, quoting Boroff v. Tully, 818 F.2d 106, 110, 1st Sir 1987. Mr. Bushy actively planned and participated in two sham transactions, 1. The sale of Sun Center's assets to Alameda Assets, and 2. The sale of the membership interests in Alameda Assets to Charles O'Donnell. In both transactions, Mr. Bushy provided the money for the purchase price. He then lied about his role in these transactions at the Rule 2004 exam, and at subsequent depositions given in connection with this bankruptcy case in an effort to hide these business dealings from his creditors. These false statements, made under oath in connection with his bankruptcy case, were knowing, fraudulent, and material, and warrant denial of discharge under 727, A.4. To review the federal court's entire opinion regarding the asset dump and buyback strategy, click the following case citation, United States v. Bushy. If you are facing an SBA loan default involving an SBA unconditional guarantee or a Treasury/Bureau of Fiscal Service debt problem, Contact us today for a free initial consultation with an experienced SBA or Treasury workout attorney at 1-888-756-9969. We can analyze your SBA loan, Treasury's Bureau of Fiscal Service debt or private collection agency problem and advise you on a range of potential solutions.